A very warm welcome to the 123rd edition of Europe Calling, Digital Services Act, a basic law for the Internet. My name is Maximilian Fries. I'm the Managing Director of Europe Calling, and I'm delighted to be able to welcome you tonight and to be your host. We have 4 excellent speakers, which I'm very happy to be able to welcome here, and I will introduce them as we go along. First, I would like to give you a brief overview of tonight's evening. So, Digital Services Act. Alexandra Geese will provide us with a few insights and introduction. Then we have reactions and assessments from Markus Beckedahl, Professor Zuboff, and Sven Giegold, and we'll of course have time for Q&A. You'll be able to post your questions in the Q&A section. If we have time, we will of course also put you up on the screen so you can participate in the debate. So yes, send us your questions via the Q&A section, or just raise your hand, your little yellow hand, if you would like to participate. Also, very important, this webinar will be recorded, so just for your awareness, this will be available for posterity, and everything you say here or post here will be recorded. And without further ado, I would like to pass the floor to Alexandra Geese now. She's a digital expert, member of the European Parliament for the Greens EFA party group, and she was also a member of the negotiating party for the DSA, also a founding member of Europe Calling, so she's wearing at least 2 hats tonight. I think you're joining us from a party meeting in rural France, so I hope your internet connection will be strong enough to join us here, and we're looking forward to your introduction to the Digital Services Act. Yes, thank you very much for your introductory words, and a very warm welcome to everyone from me as well. And as Max Geese just said, I am in the countryside in France, which is very nice for me personally because it's a beautiful place here, but it does mean that the internet connection isn't particularly stable. But that's also the case sometimes when you're in Germany. So, well, let's see. There's also a bit of background noise, or there might be anyway, so apologies for that in advance. I hope you'll be able to hear me correctly. And I would like to talk about the new basic law, the new constitution for the internet, the Digital Services Act. And we as Europe are the first democratic continent to set rules for all platforms, all digital platforms, but in particular the very large online platforms. So that is a big step, and I would like to give you a brief introduction which really takes you through the main aspects of this law, so it isn't so abstract anymore. Here's my presentation. So the breakthrough happened in the night from Friday to Saturday, which also meant that German reporting, well, was a bit slow, let's say, because journalists weren't quite present on Saturday, and of course there were other European events happening throughout the weekend, the elections in France, so you might not have heard that much about the Services Act yet, but I'll give you the details.
Jetzt bewegt sich meine Präsentation. Jetzt so geht's. Genau. Also, was war eigentlich die Ausgangslage?
So, what was the original situation? The Commission tabled the first suggestion for this law, the first draft, in September 2020. But of course, that is something that everyone had been working on for a long time. And the goal that had always been stated was to promote digital economy in Europe and to make sure that large platforms would also establish themselves in Europe and would have a positive framework. And then national authorities and also civil societies voiced their concerns and said, well, we have to implement our existing legislation at first. If we have illegal content, for example, in one country, if there are orders from a German country to work against that, then that has to be enforced. But on the other hand, the users always said that their right to freedom of opinion, freedom of speech in the internet cannot be cut or deleted arbitrarily by these platforms. So that was a very important concern as well. And so while we were working on the DSA, we also realized that the fight against disinformation and the fight against hate speech was another major aspect. So in general, negative influence of social networks, social media, is something that we wanted to focus on as well, because they do have an impact on political decision making or creating of political opinions. And that is why we didn't only want to focus on content, but also on the platforms in general. How about the scope of this legislation? Of course, a lot of these platforms are established in the US. TikTok is established in China. So how about our possibilities to enforce this legislation? Well, in terms of the DSA, we focus on the recipients or users of services which are happening, which are offered in the EU, irrespective of the place of establishment of the provider or the platform. Liability was also a very important issue. Intermediary platforms, for example, can they be made liable for contents which are posted on their platform, which are tweeted via their platform? That is also not the case in the e-commerce regulation and is still the case here. So for non-user generated content, these platforms cannot be made liable as long as they are not aware of these contents. And there is also the ban on a general monitoring. Now, one very important point, which I already alluded to before, orders to act against illegal content or orders to provide information from authorities in the member states have to be enforced and have to be enforced or implemented by the platforms. There are very clear rules on how to deal with illegal content now, which have to be followed by these platforms. So as the Greens, of course, we support this. And we wanted to implement this for judicial authorities, not just for civil authorities, because we have to make sure that the police, for example, can get active against some providers. But that is the compromise that we are looking at now, and I think it's quite a broad compromise, so it is okay for us. It does mean, however, that court decisions of German courts will have to be revoked. So we'll have to see how that goes regarding Twitter, for example. Then points of contacts, legal representatives. There has to be a point of contact, a central point of contact declared by the platforms or the providers of services to be able to communicate directly with the authorities, but also with the users, with the recipients of the services. And that also applies to service providers who don't have an official establishment in the EU. They still have to have a legal representative, a legal entity here in the EU, which is a contact point. So we won't have a case as we have with Telegram, where we have a lot of illegal content, but as a domestic authority, we didn't even have a contact person or a contact point. That situation will no longer exist or will be made impossible by the law. Now, terms and conditions and transparency. So terms and conditions and general standards when it comes to moderating contents have to be objective. Also, when it comes to non-illegal contents, even if they are undesirable content. So these kind of moderation rules have to be objective, have to be applied non-arbitrarily, and that means such a case as was sometimes the case with Facebook. Francis Hogan told us that prominent users or well-known users could basically do whatever they wanted. Their people were moderated by real people especially when it came, or even when it came to illegal content, but normal users who didn't have this kind of special VIP status were just subjected to arbitrarily applied upload filters. And that can no longer be happening. We have to have uniform standards. That is what this new regulation says, and they have to be applied by all platforms. Of course, basic law or basic rights have to be taken into account as well, and a machine-readable transparency reporting has to be made available once a year as well. Very large platforms also have to disclose how much staff they have. I'm sorry, there's a lot of noise in the background, says Alexandra, but I hope you can all understand me. So these very large platforms have to disclose how much staff they have and how they train this staff and support the staff when it comes to moderating functions. And there is an interesting phenomenon with regards to that. In Germany, we have a lot of staff usually who work for platforms and do the moderation because, of course, we have a very strong civil society in that regard. They monitor very closely what's happening there. But in other countries, that is not so much the case. Like in Eastern Europe, for example, disinformation is not really a big issue in the minds of people, and there is not a lot of moderation either. Now, we have a vaccination rate of only 28% in Eastern European countries, so we might wonder whether those two are linked. But anyway, I'll leave that up to you to decide. But that is what we negotiated, and that will be the rule now. And what I just said, so enforcement of national orders against illegal content, but also terms and conditions which cannot be used arbitrarily anymore. Those are aspects which are very relevant for the debate that we've listened to or read about today. Takeover of Twitter by Elon Musk, who said he's only buying Twitter because he doesn't want moderation anymore. Absolute freedom of speech is what he calls it. Everyone is allowed to say anything they want. And those rules, however, the rules that I just described to you will apply to Twitter as well. So in Europe, he will not be able to do what he said today. Now, notification procedures. Harmonized notification procedures to notify potentially illegal contents. That is basically a very important point which we already have in German legislation, and that will become European legislation in a different way, in a different shape, but still the idea is the same. Very clear rules on notifying potentially illegal content. And there might also be more rights for recipients and users of services by using these notification procedures. It is also obligatory now to make sure that there is a complaints procedure in place that users can use, and another obligation to have out-of-court dispute settlement procedures to make sure that users, that recipients of services have the possibility to complain, to do something against something where they were mistreated without having to go to court. Next point, online marketplaces. There are, of course, very dangerous products available online, which you wouldn't be able to find in a European shop because they are simply dangerous. And now there are rules for these online marketplaces. One important aspect is traceability. So products have to be registered to make them traceable, and databases have to be used for random samples to test this traceability. That is something that doesn't really go as far as we would have wanted. We would have wanted the same level of consumer protection online that we already have offline, but there was a lot of resistance from the European Council, from the different member states there. The next area also is important when it comes to systemic questions. I've already talked about different types of content that we have to deal with, but there are also questions such as what do the platforms do to create all this kind of problematic content? What is there a contribution by them? What role do they play? And we've heard what Frances Hogan told us as a whistleblower. We know that there are negative consequences. For example, very polarizing contents will be further distributed by algorithms and will further create a heated debate and propaganda speech, etc. So now the platforms have to explain how their recommendation system work. Users have to have the possibility to understand why they are seeing a certain type of content. So transparency is very important. And very large platforms also have to create an option to be able to see those contents which are not personalized, which are based on profiles. We also wanted to have a chronological option here. Unfortunately, we didn't get a majority for that, but at least we got this point. Now, manipulative practices, dark patterns, that is the kind of technical term here, which basically means that users are confronted with being pressured into decisions. A typical example would be the cookie banners. So you have to decide whether you give consent or not to cookies, especially when it comes to data processing. And we all know that it's always very easy to give consent for everything. However, it is very difficult to refuse your consent. You don't usually have an easy link that you can click on the first banner, on the first page. You have to really search for it, go to the next page, and some really hide it, so you can't even find it. And that is something that is no longer acceptable to us and that we want to tackle with this new law. Then again, you are constantly bothered if you've refused your consent. You will constantly be asked again and again and again, and it's often difficult to unsubscribe or close an account, etc. And we, as the Parliament, thought this is a very important aspect because if you are not forced into giving your consent, you can also make sure that not that much data is collected. With Apple, for example, you sometimes have the possibility to say yes or no when it comes to data processing. And globally, about 80% of people say no, they don't want this kind of data collection. However, many people simply say yes because they cannot find the no option. It's just too difficult. And that is something that we want to change. The solution, which was found via this new act, is a bit tricky because we said, yeah, we have to have a clear option to not give consent. However, the practices that we stated as problematic in our Parliament's report have not been, well, copied, so to speak, into the law. And we have a certain article, a second article, which says that existing consumer protection laws or activities which are covering by existing laws would now not fall under these new rules. So there might be some exemptions. That is unfortunate, but is unfortunately not the case, and we don't have as much legal security anymore.
Right, another very big and important topic is surveillance advertisement. And this is something we really fought for, and other members of the Greens. Online advertising is one of the financial foundations of today's internet. But today's business model operates on the principle of surveillance capitalism, meaning creating comprehensive data profiles on individuals that enable manipulation and control of entire populations. This I really have to explain was one of the main targets that we wanted to achieve in this in the Digital Service Act. Well, the deal, let's say, what was its outcome? It's sort of medium lukewarm. We have achieved a prohibition of advertising based on profiling, which relies on sensitive data. So that would be political and sexual orientation, trade union membership, or religion. Now, at a first glance, this might sound great. However, in legal terms, it's not very clear, and it actually is a far cry from what the Parliament had demanded. What we asked for, what we demanded was that any kind of targeting based on desensitive data would be prohibited. And this very complicated and complex phrasing, the terms chosen, is a compromise that goes in the right direction, but it's not quite clear what the specific impact is on those who run these platforms. What we did achieve was a prohibition of profiling-based advertising that uses personal data of minors. However, here, the challenge is it's really hard to say who are those minors without allowing the platforms to collect more data and create more profiles. So the glass is half full, half empty, if you like, because we didn't get everything we wanted to achieve it. However, it's also half full because we have managed to explain that this kind of advertising, that this kind of profiling is harmful. And yeah, we didn't achieve a total ban, but I think we're about to we've closed the door, but we still need to turn the key, if you like. Now, I think we're going to see more in the future. Now, the rules for the big ones, the VLOPs, this is a very exciting part of the DSA because we do not find any other legal act where this is provided and stipulated. So here we're looking at the systemic risks produced not by the users, but by the platforms. Here, it was recognized that there is a risk for democratic societies. The solution is rather complex, but also rather elegant, starting with risk assessment and mitigation that the very large platforms need to carry out every year. That is to say, they have to answer to the questions in what way their design and the algorithms influence the prohibition of discrimination, what is the impact on consumer protection, on the basic laws, but also anything dealing with violence, gender-specific violence or mental health of the users. Those are just a few examples. And here you see that a number of very specific issues are taken up that we are dealing with. For example, Russian disinformation on COVID, or the question why young girls are driven into anorexia. This is what you can put under this category. In their, the VLOPs must now conduct this annual assessment of risks. However, these risk assessments, at the same time, are the legal basis for independent research. And that's where it gets really interesting. They might be employed by civil societies organization, and this is a great success achieved by the Greens, because all these very large realms weren't even covered at the beginning. So researchers, not just working for research institutes or universities, but also working for organizations and civil society. And they've done excellent work over the past years, can verify, can evaluate this risk assessment, and they can be granted access to the data of these very large platforms to make sure whether data privacy rules are adhered to. So in the future, we will see major research projects also to prove the impact, the influence that these platforms take on society, on democracy. What else? There is a new article that the Commission has brought in the very last minute, so to say. This is crisis management in very exceptional situations, like now with Ukraine. Many of you, I'm sure, will have heard that RT, Russia Today, and Sputnik Day have been prohibited, not just the TV stations, but their content, all of our content on the internet. So this is a very serious violation, and disallowed for sanctions, of course, the basis for sanctions from abroad. And of course, it made us see that for these situations, it might need a different legal act to be able to take action. So the EU Commission, on recommendation of the DSA panel consisting of the 27 member states, can require VLOPs to take action to carry out specific risk analysis, for example, or take other measures not specifically outlined in the existing text. However, this crisis situation must be limited crisis response must be limited in time, maximum 3 months. I think here in legal terms, in terms of the rule of law, we can do a little better. There's still room for maneuver, but what's important is that we have a very clear and transparent public procedure. So this is something very positive. The Commission's decision must be made public, as I explained. So access to platform data, coordinators, so somebody who would be responsible for the all over platforms, and there's a European body, European panel on digital services representing the national bodies, and the Commission is responsible for direct supervision and enforcement for VLOP and advisors on cross-border cases. This is very important because what we need is to be able to act against these very large platforms. At the same time, with smaller platforms, we have to make sure that distance isn't too large and that we need to understand the national context. This is where the member states play in. Now, what kind of sanctions do we have on enforcement? Payments up to 6% of global turnover, penalties or periodic penalties of up to 5% may be imposed for persistent violators until the non-compliance is done away with. So interim measures, for example, may be ordered to be put an end to the violation, or in special situations, the service may even be suspended altogether if somebody's life is threatened, for example. And this is very much up to date. Elon Musk, for example, buying Twitter as a hobby, if you like, and these penalties are something he can pay with his pocket money. So yes, it's a long way to go still, but other possibilities exist to sanction platforms and people. And what's interesting is that VLOPs now share the financial burden of their own supervision via fees. So they need to pay a certain share for the costs incurred because other bodies need to monitor them. So it's comparable to banks, really. So this was an amendment by the Greens, the Commission. It wasn't accepted in Parliament, but the Commission and the Council have taken it up again. Max is getting a little nervous. So what are my conclusions? I think that we have seen a breakthrough in Europe. The day before Hillary Clinton and Barack Obama have tweeted it. So there is worldwide attention, even from the United States, on what's happening here. I think the US is a very good example here, because there's no liability for the opinion represented on the platforms, but the platforms are made responsible for their actions. And here we've seen a shift in things and debate, section 230. This has been filled with life now, because it's the question is, what are the platforms doing? What are they responsible for? So the systemic risk is important here, and the ranking based on the criteria that we see today, these are recognized and they're addressed. However, we still see limits, the prohibition on profiling, for advertising, and the modification of recommendation system. This doesn't go far enough. The same goes for dark patterns. The profiling for recommendation systems has not been addressed, and the systematic risks are that we see research done into that, but we don't see a total ban. So we would need more information, more intelligence to see how the proliferation can be modified, and what are the mechanisms that we can use to stop this without cutting down on people's freedom of opinion. But things are moving, you know, it's an avalanche, and we see changes from day to day. So we have the instruments, but it'll take some time to make good use of them. Thank you so much, Alexandra. Well, I didn't mean to interrupt you. Well, Alexandra is not only a negotiator, she is a legislator, and she explained this act in all its details. And she was involved in its preparation. So that was great, a great presentation. Very comprehensive, so we learned a lot. I'm really looking forward to the comments of our three guests. Let's start with Europe, Markus Beckedahl, and then we'll move over to the United States, to Professor Zuboff, and then we'll move back to Sven Giegold. Markus Beckedahl, you will have met him, come across him. That's publica.org, publica, founder, so one of the great pioneers of the defenders of freedom, the freedoms on the internet. From 2010 to 13, he was a member of the Enquete Committee of the German Federal Parliament. Markus Beckedahl, we're very happy to have you. We're looking forward to hear your opinion, your evaluation on what Alexandra has presented. Thank you. Thank you for having me. Well, I'm very happy that we can discuss the DSA results tonight. It was great publicity looking at today's and yesterday's announcement that Elon Musk is planning to buy Twitter. So this puts oil into the fire and poses the question, how can we interpret these questions and the freedoms on the internet? And perhaps rein in the very large platforms. So I think this is a wake-up call, the fact that Elon Musk wanted to buy Twitter. And I'm very happy that the political sphere has woken up before and has found an agreement. I would have been happy to see this 5 years ago. But as Alexandra explained, it takes a while until this has entered into force, until there's been more research, and then we know more about the new opportunities created by the DSA. Perhaps we'll probably see a few years go by before we have more room for maneuver. But then anything's better than what we had now, looking back at the last 10 or 15 years. So looking at the little regulation there was, platforms and operators and providers could do pretty much what they wanted to do. There was way too little democratic control mechanisms. So many things have been explained from a German perspective. It's very interesting to see that a number of the new mechanisms is something that we've seen before with a number of acts and regulations on the media, on the internet. So we have a number of legal acts, and this has been moved to a European level. And that is great because our users see that they're getting more rights to defend themselves against what is going wrong with the large platforms. But we haven't seen all advantages or benefits there could have been. But with our group Netzpolitik, many people turn to us, for example, that feel totally helpless when their account has been blocked or deleted by Twitter and they don't know who to turn to. They can turn to the press, but otherwise, nobody seems to react if you ask for your account to be unblocked. For some people, this is a disaster. Others say, okay, well, never mind. For many people, social media are a place for exchanging, for getting in touch with other people. And if your account is blocked, you feel pretty much left out. And it would be a very good thing to have a better way to defend oneself and to raise objections. So this is something very exciting to see is it going to take ages until, let's say, the Twitter or YouTube support will get back to you? So we've seen this with other debates, like the copyright reform. Of course, companies are not so happy about that, but anything like this, any regulation like this means more more costs, and this doesn't fit in with their business models. I was very happy to hear and to see that researchers and non-governmental organizations can have better access to data. That was not possible before, and I think there will be a number of improvements because of that. And a reality check will show where this goes. At the moment, it's a sort of Damocles for any researchers who are trying to understand how these algorithms for recommendations work, in what way they go against the general terms and conditions, and what are the legal means, or what are the legal loopholes. As I said, this was one of the highlights.
However, the DSA is not really the basic law, the kind of constitution for the internet, which it has been portrayed as in the debate. Alexandra already said that we don't have a comprehensive ban of personalized advertising, which is what we would have needed, which is what have been urgently needed. And again, we didn't really reach that, but still negative consequences of social media have to do with personalized advertising, have to do with the fact that business models are really based on this kind of practice. They want to motivate people to interact more on social media, to collect even more data, to offer even more personalized advertising. And if we want to combat disinformation and hate speech, then we won't solve that problem if we still allow all that kind of personalized advertising and profiling to happen. Even if data cannot be used for generating these profiles anymore, so that's a tiny little step. At least children and young people will no longer be able to see this kind of personalized contents. However, how will mobile phones be able to detect who is looking at a certain website, or whether it is a young person or a child using the tablet or someone else? So how is that being put into practice? Well, let's see. So apparently there seems to be an issue with monitoring and with oversight. We have learned from that, and the implementation, traffic jam, so to speak, when it came to Ireland, for example, is meant to be overcome by creating a new board and by passing new competences to the European Commission. I think that might help. I think it also makes sense to have a kind of independent agency on EU level. We'll have to see how we can deal with that then on a national level, how supervisory activities or monitoring activities will be distributed. But in the end, it is all about whether implementation can be efficient and effective, and about whether these rules work well and how quickly we can learn from the fact that some rules might not be working that well. So how quickly can we then adapt the rules or extend the rules, adjust? So to go back to my initial words, we don't really have a constitution for the internet or a digital basic law then, but it is a very good first step. Thank you. Thank you. That was a very interesting contribution from you, very interesting insights. A quick piece of information for everyone listening to the English translation. Apparently there's some kind of overlap, sound issues. We're trying to fix that. So just bear with us and we'll do our best. Now, our next speaker is Professor Schubov, Professor Emerita at the Harvard Business Schools, and she is really a pioneer in the just digital world. Her bestseller on surveillance capitalism has been translated into 26 languages, has received various awards, and I'm really delighted that you've joined us again. It is your second time during Europe Calling, a seminar or webinar, and I've already posted the link to your previous webinar, and now we're looking forward to what you have to say on the Digital Services Act. Thank you.
Thank you so much, Max. Can you hear me well? Yes, good. I'm so happy to be with all of you here today. Alexandra, it's such a pleasure to see you again, my friend. What a great day this is. This is a great day, a great week for democracy. And I'm going to try to give you, to begin with, a little bit of a different perspective, because you all have been working very hard on every detail of this gorgeous new piece of legislation. So I'm gonna come at this from a slightly different level, you know, the airplane view down. And what I want to say is that to those of you who spent an early Brussels spring debating the final shape of the Digital Services Act, and those who stood by eager for the outcome, and even for those who were never even paying attention, hear this. The Digital Services Act is not just another legislative drudge on Brussels' endless conveyor belt of words. It is a bold reckoning with history. The first comprehensive declaration of a democratic digital future founded on the legitimate authority of democratic rights and rule of law. And as a brief personal footnote, I will say that I've been waiting for this for 40 years, and I could not be happier, more inspired, and more grateful. In defiance of the extraordinary wealth and unaccountable social power of the tech giants and their growing institutional order, the secret massive scale extraction of human generated data, which is the source of that wealth and power, in defiance of their profit-driven corruption of information flows that are mission critical to every democratic society, and in defiance of their relentless annexation of human rights and democratic governance functions. And under the shadow of the murderous Russian assault on the Ukrainian people and their democracy, the European member states, their parliament, the EU Commission, and the European Council together set ablaze the beacons that rim the mountain peaks and proclaimed to the world that democracy is back. For the first time in 2 decades, since the origins of surveillance capitalism at the turn of the 21st century, there is hope that the principles of a self-governing demos might survive the digital century. And that is a hope that until now, we had no justification for. For the last 2 decades, democracy ceded our critical connected information and communication spaces to the private corporations which grew into the surveillance capitalist empires. This was an act of democratic self-evisceration, and self-evisceration at the expense of the most central functions of an information society in an information civilization. And yet this has been our fate for the last 2 decades. And if we ask ourselves the question, why is it that one man can take out his wallet and purchase a significant chunk of those connected information and communication spaces that are critical to our societies? The answer is there in the 2 decades that our lawmakers, especially in the United States of America, my beloved country, ceded control, consciously, voluntarily ceded control to private capital to run and regulate, to set the rules, the norms, and the values of these spaces. As a result, we have ended up in a zero-sum game where the deepening order of anti-democratic surveillance economics propagates democratic disorder. And when we look at it from this vantage point, I think it is accurate to say that surveillance capitalism's current rise to dominance can be understood as an epistemic counter-revolution, an anti-democratic coup expressed in the assumption of authority over the constitution and production of knowledge, as well as the power that accrues to such knowledge and protects that authority. The only institutional order capable of contradicting, which is to say, threatening, obstructing, undermining, interrupting, and outlawing surveillance capitalism's knowledge dominance, is the liberal democratic state backed by its legitimate authority and legislative powers. Surveillance capitalism's continued institutionalization depends upon meeting the challenges of successive and deepening contradictions with its grizzled but still potent antagonist, democracy. And though surveillance capitalism is the younger challenger, it has shown us that it embodies novel strengths that have been able to overpower and surprise a defenseless society. Democracy is the old and slow incumbent, that is true, but it brings advantages that are difficult to rival. These include the ability to inspire democratic action, the ability to inspire fear in adversaries, and most formidable, the legitimate authority and requisite power to make, impose, and enforce the democratic rule of law based on cherished values, ideals, and principles. That is not nostalgia. That is survival. That is the possibility of a democratic and a human digital future. This democratic resurgence that you have led is long overdue. And as your friend from America, I thank you for leading the way. I want to stress in closing that it is very important for all of us to remember, to know, to internalize that this is the beginning of a multi-phase democratic response that will take us through this decade, at least. There will be triumphs and there will be setbacks. what the DSA accomplishes is precisely what had to be accomplished in phase one. It breaks the sound barrier of inevitability. The corporation's complacency, their audacity, their ability to do whatever they want to do, to take whatever they want to take, free of law, free of obstruction. That day is over. It breaks the sound barrier on the people's resignation and helplessness. Those are now behind us. They're part of an earlier chapter in this narrative. We have turned the page. We are in a new part of the story. What the Digital Services Act does is that critical action. Some of you may have heard me say this before. In fact, I might have said it the last time we were together because I'm obsessed with it. Because we are, as the Titanic, heading for the iceberg of a digital future that is ruled by computational governance and anti-democratic forces, a fundamentally anti-democratic social order. But what you have done with the Digital Services Act, whatever the failings or the incompleteness that still frustrates you, what you have done is to turn the Titanic away from the iceberg. And all you have to do is keep going. All we have to do is keep going until we get to the shore where that democratic digital future is within sight. What the Digital Services Act does is it assigns the digital to democracy's house, where it always should have been. Now the digital lives in democracy's house, expected to be a contributing, both in finances, brilliant, but also in joy, a contributing, joyful member of our family. It creates the possibility for the first time in 20 years that the true fruits of the digital age, knowledge, problem solving, will finally be returned to the people to meet the challenges of our communities, our families, and our planet. It opens the space for democracy enhancing innovation. Enough of this performative talk of innovation that has only led to powerful monopolies on the entire market structure of knowledge production and consumption. The success that is still within our reach in this decade depends upon our Realpolitique, our sense of the Realpolitique, and that must start now with you. That begins with a recognition that everything we are talking about is not a story about technology. This is a story about power. And you must be fearless in asserting the democratic power that is required to do battle in this zero-sum game. The issues are not just regulation. Regulation takes a thing and it tries to make it a little bit better, a little bit less egregious. It tries to mitigate a thing. We need a different understanding, not regulation, but reinvention. Because everything about this institutional order is founded on the illegitimate and illicit bed of sand that is the secret massive scale extraction of human generated data, which is the foundation for every other social harm that you have talked about every other social harm addressed in this legislation, whether it is the wholesale ability to manipulate collective and individual behavior, or the dire, urgent problem of corrupt information overtaking information integrity, with the scourges of disinformation that are destabilizing our societies and our institutions. The powers that you have accrued to the Digital Services Act create the conditions for this Realpolitik. But the very first thing that has to be addressed is that the Digital Services Act must be funded with all of the resources, financial and human, to get this job done. We are not going to have another chance. We are not going to have another chance to go around this circle and grab the ring. We've got to get this foundation right that the Digital Services Act lays for us and move on from there, because there is still more work to done, because there is still more work to get done to move us to the right place if we are going to end this century with a democratic and digital future. You've talked about so many of these key pieces that have to be put into place: opening the black box, the transparency, allowing us democratic officials, the folks who are going to come into the new institutions created by the DSA, and be able to open up the hood and look inside and monitor and judge and assess, and the researchers who will be able to do the same for the first time. That opening up the black box is a fundamental shot across the bow to the secrecy, AKA surveillance, which is at the core of their reproductive power. And so this is tremendously important. It is vital, it is critical. But without the funding and the people, it will not happen. Centralized authority, married and in collaboration to the authority in the member states. We need it all, and it has to be real and powerful, because this is a battle for the future. You talk about liability. You talk about ending the free flowing of corrupt information. You talk about illegal content. All of these things are essential because they establish that cyberspace was always a pernicious myth. There is no place that is free from the laws of our societies. There never was, there never should have been, and it was a dangerous rhetoric that had many people gaslighted for many years, but that day too is done. And finally, I want to call attention to the difference between what is illegal and what is unprecedented. With the end of the myth of cyberspace, we say that everything that is already illegal for all of us in our lives is already illegal in the digital, and that will be enforced. That is a necessary and crucial and long overdue step. At the same time, I want us to recognize that much of what we face today is unprecedented. And because it is unprecedented, it has not had time to become illegal. It is illegitimate, it is illicit, it should be illegal, and it must be made illegal. Ultimately, if we are going to stare down all of the harms that we've been discussing so far, we are going to have to reckon with the pervasive, self-authorized, secret, massive scale extraction of human-generated data, which is the cause of the wholesale destruction of privacy that we have seen on a global basis, which is the cause of the epistemic chaos, the vast corruption of information, which is tearing our societies apart. This cannot stand. And ultimately, in order to solve these downstream social harms, we are going to have to work our way upstream to these foundational atrocities and learn how to interrupt and outlaw them. Why? For the sake of an equilibrium between our digital age and our aspirations for democracy, for the sake of opening up space for the brilliant kind of innovation that we all crave, that will advance our ideals and our form of government. And finally, what is there left to say but that every people in every country, every child today and every teenager, when we look at every artist and what is being produced from every domain of the art world, what we see in every direction are people projecting a dystopian future. Our children, our young adults, our artists, and people all over the world, because we have stumbled into a future that none of us wanted and none of us would have chosen. This future is our accidental dystopia. And with the Digital Services Act and the Digital Markets Act, and finally, a GDPR that gets enforced with all the might and muscle of the European Union, we can change that fate. You are on your way. Do not falter. Celebrate and fight on. Thank you.
Wow. Was ein Plädoyer für die Demokratie.
Wow. It was so great to hear these words, pro-democracy, a real plädoyer. Thank you so much. That was fantastic. It was so great to hear you. Fantastic statement. I looked at the clock here. That's why I was sort of getting a bit agitated. It was brilliant. No way I was going to interrupt you. Well, Sven Giegold will be our next speaker. Many of you will have met him before as Secretary of State at the Federal Ministry for the Protection of Climate and the Environment. And before 12 years, he's been working with he's been a member of the European Parliament, and I've worked with him, and he was spokesperson in the Committee of the Greens, and he is the inventor, the founder of Europe Calling. I think this is what you need to call it. So what's his role in the bringing about of this DSA? So Sven, we're looking forward to hearing what you have to say.
Ja, ich werde erstmal ein paar Worte auf Englisch sagen. Susanna, thank you and great to have you here again. And actually, you provided us with a small cultural shock, because it is a German-American encounter. So you have Alexandra, who has worked for so long, achieved so much, and giving a self-critical, cool assessment about the law, and basically a long list why we still have to be unhappy. Markus Beckedahl, he matched this already a bit more optimistic, I have to say, yeah? So this was, but that was German civil society in preaching form. And then we got the American cultural shock by someone who speaks out openly, speaks about values, not about rules. We are so boring in America, in Germany, Susanna, that's the truth. And so it's not about you, or it's very much cultural. So such speeches are very rare in Germany. So I'll switch back to German, but I had to share that directly with you.
So, I just wanted to share this.
Look, I'm speaking actually, and I want to try at least a bit to match what Susanna has said.
So I'm now speaking to you from the building, and even from an office that could have been the office of Müller-Armer, who was Secretary of State, who at the time, after the war, actually turned the rules of the market economy into practice, into practical rules. And this happened right here in this house. And this was the consequence from fascism, the Nazi rule, which had become possible with capitalism becoming. So the consequence of the liberal economist was that we have to do everything to make sure that this never happens again. We don't want to see such concentrated powers in the markets. Just checking with Max whether, yeah, the connection holds. Great. Some of the videos were switched off, so I wasn't sure. So there was a number of other reasons, anti-Semitism and more, and the fascist structures. I'm not going to go into repetition here, but one of the consequences, one of the conclusions drawn by the Federal Republic of Germany afterwards was that, yes, we are pro-market economy, however, under a very sound and solid control system. And the concept behind that is the social market economy, which is not to say that market economy had been harmful and ecologically damaging. Alexandra can say more. In many ways, it is the fact that being active on the market, this is something that we haven't really fulfilled. However, the target, one thing we achieved is that the state has come up with rules, making sure that private enterprises work for the benefit, for the well-being of the majority. So now with the European single market had been brought forward, progress was made here in this house. We saw the same question. So does that mean we still have democratic rules? The liberalization of trade was adjusted and additions were made. And this is why when it comes to environment protection, protection of consumers, anti-discrimination rules, Europe plays a leading role. Anything that we've agreed upon together with the member states and under the monitoring of the European Union, of the Commission. It's not perfect, but it was the first time that we managed to make sure that the rules for a market that goes beyond our borders have been set democratically, and that we have, made sure that internationally we have these rules and they're followed. Now, looking at the new forms of capitalism on the internet, so we have radicals who asked, well, is this our moment? Can we now have a room without state control? So, no, the state does interfere. The internet is an open room, a public room, so just as why those rules must hold. So this was a first step taken here. Now looking at the Digital Market Act, we have seen rules for competition, especially with the larger actors, and the digital services. What we've seen here is more protection of consumers. And at the same time, we protect the freedom of opinion and the liberties of the players. And the focus point is not just each and every single rule. What we've seen every now and again, repeatedly in European legislation, is that the first pieces of legal acts, they were rather weak. They didn't bring about much change, but slowly, bit by bit, with the help of European democracy, things were brought forward. And the decisive thing is that we've managed this deal. This deal has been struck with might and muscle, and more might and muscle than people would have believed just a few days ago. And the centerpiece of this business model is that we need to prohibit this kind of profiling, of advertisement, the surveillance capitalism, as Professor Zuboff called it. And this is something we've only begun to change. So we still see the centerpiece of the business model. However, these firms, these providers are now monitored, and there's an institution, there's a place you can turn to with complaints. And what the providers and entrepreneurs will find very unpleasant is that in a couple of years, Alexandra and her followers will come back and check on what does not work, which is probably hell for everybody who thought they were above the law. So now that we have this act, which is brought about in co-decision mode with the 3 European institutions, and now we'll see what the experience tells us at the level of companies, of providers and users. And then we can still make the framework more stringent. Also, NGOs can come in.
So this is the central issue. So we have rules which are enforced. They're not perfect, but they are there. And they are much better than what we have in many other parts of the world. And we have an institution which will monitor the implementation of these rules, and we have a parliament which will also monitor the European Commission, because the large platforms will be monitored by the European Commission, which is also the case for digital markets. And that means we have learned our lessons from the GDPR experience, where a company was established in Ireland and couldn't have cared less about GDPR, and then we couldn't have enforced it anyway. But now we have European, pan-European oversight and monitoring and supervision. And by self-financing, by obliging them to self-finance, companies can't even say we don't have the money. Or authorities can't say that either. In Europe, we always say, after the law is before the law. And I think the democracy can catch up now. And I think something else will happen as well. Now that in Europe we have adopted this law, a lot of people around the world will wonder, why don't we have such a law? They will ask for getting the same rules. And if then there is democratic legitimization of these rules, they will maybe even adopt stricter laws. Democracy has won here in Europe, and hopefully it will win in other parts of the world as well. There was it was a very tough battle for Alexandra. There were points where they were in the minority at the beginning, but they reached openness, acceptance for their suggestions, and we had problems in the Council of Ministers. But we were able to push some things through, and we in Germany were not the ones who blocked everything. In Parliament, of course, there were lobbies as well who managed to gain some victories. You wanted to go a lot further when it came to personalized advertising, for example, Alexandra. And of course, you had to make concessions due to the lobbies who just have so much power behind them. So there were some losses, but that's not what matters here. What matters here is that we managed to have a very ambitious regulative framework for the digital world in Europe. And that makes sure that other parts of the world will look at us, will also adopt a similar regulation. Let's have a look what will happen in Australia, New Zealand, South Korea, South Africa, and all other democracies around the world. They will wonder, why do the Europeans do that, and why don't we do that? So eventually, Shoshana will also be able to favor such a law in the US, and then democracies will reach out to each other, will connect, and will make sure that whatever money Elon Musk has available, he will not be able to influence our democracy anymore. We haven't won the battle. And of course, democratic institutions are endangered, and they are always in danger of being bought by Elon Musk or others to a certain extent. But there is an opportunity here. There is a big opportunity here to use our European democracy and democracies around the world and to shape this cyberspace in a democratic way. And by the way, this also applies to finance online. Bitcoin, cryptocurrencies, and so on is the same principle. People think they don't have to take on responsibility. They can just create their own financial space without any rules, any liability whatsoever. And the central question here is, are we able to find a way of democratically regulating this digital form of capitalism, just as we did today with the DSA and DMA? So that is where we have taken a very important step forward as a parliament, as democratic society, and I think there is something that we can still achieve. We can achieve a lot more. And well, as a German, it's always hard to be proud or to find some pathos in my speech, but I think we can be proud, and you should be proud of what you have achieved, and I think it is a day to be happy. Thank you. And I think we fixed the interpretation issues on the English channel. So now we have 10 minutes left, or maybe even 15 minutes if you have another few minutes. And I would love to have your questions now. First of all, maybe let's have a look at the written questions from the Q&A section. And please, everyone who has joined us on the panel, keep it short so we can answer as many questions as possible. And then later on, as a second round, we will hear the attendees who have raised their hands here. But let's first look at the question which got a lot of votes by Richard Gutjahr. I think it's a question directed to Shoshana Zuboff and others. How do you want to prevent that companies such as Google or Facebook can really be confronted by authorities which might not have the staff, which might not have the resources to fight against them? They might just delay the process for years and years. So the general question, how do you see that happening? How do you think that the authorities will have the necessary power? And then a question to Professor Zuboff. How was the decision received in the US? What do companies, democratic institutions say to this?
Well, on your first question, the fact of the matter is we don't have to guess about that because we've already seen that movie. For the past 20 years, I can use the American case as an example. We have something called the Federal Trade Commission. Unfortunately, I mean, it's great institution, but it's the only one with any real formal responsibility for consumer privacy. And if you go back over the various suits that have been brought against companies like Google and Facebook, which I did when I was doing my research on the big book, the FTC would put out an order that they had to do something, and then the papers wouldn't come, and the FTC would try to send teams, and they couldn't find anything, and they were stonewalled, they were gaslit, and it went on and on and on. And I wrote about it in the book as a kind of tragic tale of this little democracy institution trying to fight this mega money power institution. And they were not well matched. And that is why my first point, as far as how we move forward, is that this is our moment. Let's get it wrong by failing to fund it. We're talking about a lot of money, and it's not going to be easy at a time when people are worried about inflation and budgets and so forth. This is non-negotiable. And money isn't the only kind of muscle. This is the time to open up the doors, and all those data scientists who went to work for big tech because they were paying big money, get them back home. Get them back working for this really exciting new institution within the European Commission, because they are going to be the vanguard for digital democracy. They are going to be the vanguard for a future that takes us beyond this dystopia that's been imposed upon us. They are going to be our warriors for democracy. Get them back, pay them what you have to pay them, and get them back. So we're going to have to be really, really, really serious about this, money and muscle. When it comes to America, look, the story in America goes like this. This all began as an American story. These are American companies. And it was initially American lawmakers that allowed these fledgling internet companies to grow into surveillance empires. So American lawmakers have a lot to answer for. In the meantime, 20 years later, echoing something Alexandra said before, you look at the data in my country, everybody, I'm talking about people, not officials, everybody is over this. Everybody is done with it. Everybody wants to see tech brought to heel. Everybody's angry. Everybody's happy to get back some inconvenience for the sake of their privacy. Everybody wants them to stop collecting data. We're seeing percentiles in the 90th, 80th, 70th percentiles, enormous majorities. The people are there. And that was never true before. Even 3 years ago, that wasn't true. The elected officials are coming. There's so much more happening in Congress than has ever happened before in the last 20 years. So I'm hopeful, but we are going to be following you. And now you've set the bar. And we have no excuse to say that, you know, it can't be done because you're doing it.
Wieder wunderbar.
Wonderful. So inspiring. So we'll keep going.
You keep going.
Markus Beckedahl. I guess you could talk for hours about Elon Musk. We've mentioned it before, but of course it is a question which is very much on people's minds, so I have to address it. Someone, for example, asked, what will be the future of Twitter now that Elon Musk has bought the company? Please keep it short, but how do you see that whole issue? Well, we don't know. This is a huge black box as well. It's a big problem. It's not actually clear whether he will acquire Twitter. He can put an offer in, but let's see. He says he wants to create an inclusive space for debate. Freedom of opinion will have to be enlarged and extended. Well, that's what he says, but what does it mean? Does it mean more hate speech and abuse and violence online? I think an inclusive space is simply not possible if hate speech is made possible as well, because that excludes a lot of other people who think differently. So that's one aspect. Another point is he wants to introduce an obligation to authenticate. Well, sounds nice when you think about right-wing bots or automated systems, which will then have to be authenticated and so on. So those accounts might be eliminated from that platform. But if you continue that same train of thought, you will also be confronted with countries such as Turkey, for example, where Twitter is used against censorship. And if we have this obligation to authenticate, for example, President Erdogan could just eliminate all these accounts who use Twitter for the sake of democracy. So whatever Elon Musk says at the moment is very ambivalent, and it's still not sure at all what will become of Twitter. So I think it is even more important that we now have this Digital Services Act, because that will make us less dependent of Elon Musk's decision, whichever way they will go. Thank you. That was a short reply. And now another question which is ranked very high and which goes to Sven, and is something that I'm very personally interested in as well. Regarding banks, and I know you're very interested in banking and finance. So my connection to my bank, says Ulrich here, asks me to subscribe to Google apps or other two-factor authentication and so on. I'm asked to use a certain app if I want an account with them, and that's the case for many banks. How about the Banking Supervision Authority? Would they be able to use the DSA to act against this? Well, I'm quite surprised about all the questions we get here. It's positive that a lot of people are interested in banking and finance, and it's not just me. But anyway, Basel rules are not consumer protection rules. They are solvency rules. So they consider the liquidity of banks and so on. So that's, first of all, that's got nothing or not much to do with the DSA. It's more to do with protection of consumers on financial markets. And that is, of course, not the scope of the DSA. So I'm not sure whether there is a connection here. I don't think the DSA will regulate the kind of financial aspects of the situation that you just mentioned. But if a bank says in their terms and conditions that you have to work with a certain app or that you have to work with a certain service provider, well, you can just go to another bank. Of course, there are cooperative banks, which I normally hold in high esteem, and they now want me to use Apple Pay. I'm not quite sure why I'm supposed to do that. Why am I supposed to pass on my financial data to Apple? But unfortunately, that is not the scope of Alexandra's beautiful law. However, in Europe, we do have financial consumer protection laws, and we will also have a review of the current rules that are in place, but that's not something that is directly linked to the DSA. Thank you. So those are the most important written question, and now I would like to give the floor to especially women who have raised their hands here, because the questions that we've heard here, the written questions, were from men. We're already 1 minute beyond our time, but I think everyone is very interested, so we'll continue for a couple of minutes. So first of all, Gisela Langia, you have the floor. You raise your hand, you have the floor. Let's see if it works. Of course, it's always the tricky thing. Someone raises their hand and then they're not able to speak. You will have to unmute yourself. Okay, I'm not sure where you got my name from, apart from the fact that I registered. I didn't actually want to ask a question. Well, you did raise your hand. Oh, sorry about that. Anyway, but I am really inspired by this webinar. I think it's fantastic, and thank you very much for your hard work regarding the DSA. Thank you so much. So now, the second woman on the list, who also raised her hand, Eva Lichtenberger. And let's see what Eva has to say. You have the floor. Eva, you just have to unmute yourself and then you can ask your question. Eva Lichtenberger, just unmute yourself and then you're good to go. I hope you can hear me. Yes. Okay, great. Well, I've joined you from behind a mountain somewhere in Austria. So very fascinating, and it was a positive surprise to me how much was achieved with this new law. However, there are still some things I am worried about, and maybe Alexandra could say some more about the monitoring or supervision activity, so what will happen on the European level, what will happen on the national level, which kind of supervision will take place where. And thank you for your hard work on the DSA. And congratulations on your achievement. Alexandra, yes, thank you. So the European Commission will be responsible on supervising on very large platforms, so the ones that have more than 45 million users in Europe. The national authorities are responsible for everything else. So that's basically a short summary. To come back to the question of Richard Gutja at the beginning, so we want to make sure that we don't have a very small authority in a very small member state who will then have to fight these tech giants. And that is what we wanted to enshrine in the law by having these different level of supervision and monitoring. And we have the fees that have to be paid by the platforms themselves, which will allow for financing. That was really kind of a stroke of genius here, because we will have financing available. We will have the possibility to bring these data scientists back to Europe, just like you said, Shoshana, to make sure that we will be at the forefront of supervision and we will really be a beacon. Thank you, Alexandra. Now, Kirsten Fiedler, the last woman in the trio, who raised her hand as well. Now she took the hand down. So anyway, one last look on in the Q&A section, just to make sure we haven't overlooked anything. 2 hearts were posted for Sven Giegold, 8 votes in support of the 2 hearts. Wonderful. That's very important to mention as well. And then there are a lot of questions on cookies as well. In Q&A, we also have a lot of disappointment. A colleague from NOBI, the Austrian NGO, where Max Schrems also works, asked a few questions on cookies. So we'll take that as a last question. So what impact will the DSA have on cookies? There will be certain rules, and what does that mean for consumers, for the current debate on cookie banners and so on? So maybe Alexandra and Markus can say something on that.
I'd say Alexandra will know the answer better because she knows the text by heart. Okay, no problem. Alexandra, we're running a bit late. Hope that's okay for you, Alexandra, on cookies. And this will give you the final word. I think this will have been a wonderful, exciting webinar more like. Well, the cookies, that is something that was very close to our hearts, as I explained at the beginning. The existing rules are not very clear, I'd say. I'm not a legal expert, but existing procedures are not concerned by this because dark patterns or manipulative practices are excluded if they fall under the GDPR, the General Data Protection Regulation. Well, what we were aiming at was to say clearly and transparently, if it's manipulative, like one button is smaller than the other, then it's prohibited. This is what we did not get. So I guess that we have to keep up the legal fight under the GDPR. The DSA, I believe, will not hinder this. We would have liked to get further. What was also very close to our hearts and would have made things a lot easier and was how you can set up the browser. Do not track was something that we have seen in the regulation, or it's continued to be negotiated under the regulation, because this is a question of consumer protection. That once you set your browser, and it should be respected, your settings. And I'm afraid that here again, the European Council was in resistance. They objected, but that would have been our dream and we didn't get there, but we'll keep fighting. So this would be the little loopholes of the DSA, I'm afraid. So the final word, the conclusion, Max, if you agree. Professor Zuboff, you were very reassuring. It was very comforting to hear your speech. At national level and at European level, it was a breakthrough that we've seen with the DSA, and you spoke about a global breakthrough. If you're an expert, if you're a politician working on the details, you're always disappointed because you feel like you could have become the Olympic champion, and then you're only ranked 4th. You didn't get a medal. As Markus Beckedahl also explained, but of course you are right. It is like a victory. It's like winning a medal, the Olympic Games. It's perhaps not the world record. There's still room for more, but still, it's something. And I'll now switch to English.
Professor Zuboff, that you said this is a gorgeous piece of legislation that really reconciled me with all the hours of lost sleep. Why, in the first place, I think you said it perfectly, it breaks the sound barrier of inevitability. I can't even pronounce that word. Because when I started working on it, and I started, one thing I want to do there is to stop surveillance advertising. And the second thing is I want platforms to be liable and responsible for the way, their own mechanisms with which they disseminate content and create risks. A lot of people told me, you will never be able to do that. We can have rules on content, but you will never touch the platforms, and there's no way you will touch the profits and the business model. And we showed that this is not true. We are touching the business model. We are touching the surveillance business model, the advertising model. And we made really serious, very serious obligations to assess risks mandatory, and we established independent oversight, not only from democratic institutions like national authorities and the EU Commission, but also by independent researchers and civil society. And this is absolutely a major breakthrough. The second point I would like to make is that, and that a few of you made, Markus Beckedahl, I think maybe Sven Giegold as well, that enforcement is key here. Enforcement is absolutely key because we have the data protection regulation in Europe that is not perfectly enforced, and this is one of the causes for many of the problems we are having now with surveillance capitalism. We shouldn't even have that in Europe if GDPR was properly enforced. So we have to make sure that the DSA and the DMA will be properly enforced. But I think we have a good basis with the EU Commission. I see the EU Commission has a great appetite to do so. They will start with a few hundred people, and I still have hopes that an old green project that also Sven Giegold has been pursuing for many years, a European agency for digital oversight, for platform oversight, might be the next step, because we will not stop here, and this is a very good basis, and the fact that the platforms themselves have to pay for it makes sure we have adequate funding. The third point, I pick it up again from Professor Zuboff. We have showed that the self-governing demos may survive the digital age. So democracy is able to control corporations and to choose where the people want to go. Technology is a means, it's an extremely useful means, and democratic societies are choosing now finally themselves what we want to use them for. And what I think we need to do now, and what I will do in the next years, we have to make sure that democracy not only survives in the digital age, but that it thrives in the digital age. And you told us, Professor Zuboff, not to falter. I will not falter. Thank you all.
Very much. You will never falter, Alexandra. I know that. Bless you. Bless your heart. Thank you so much.
Thank you so much for being
inspired.
with us.
I'm so inspired by you. Thank you.
I think we are all very, very much inspired by you, starting from your book, but also from your personal presence, which is totally incredible. Thank you so much.
It is my privilege to share this.
Vielen Dank. Es war wirklich eine große Ehre. Es war großartig.
Thank you so much. It was a privilege. It was an honor. Thanks everybody who joined us. Thanks to our guests on the panel and everybody who listened out there. Several hundred people followed us. Thank you so much. The recording will be available as of tomorrow. Wishing you a wonderful evening. Thank you. Thank you for being with us. See you at the next webinar.